Oh, good afternoon, everyone, and thanks for taking the time to sign up for the webinar and joining it. What these are constructed as are information sessions. As you'll be aware, there's what's known as an interim decision by the scheduling delegate, and the mechanisms around scheduling will be discussed by my colleague Avi Rivera. And so it's this process is set out in law, in regulation, and in our Act. And so after an initial or so-called interim decision is made, there's an opportunity where we call for further public submissions, and that's over a period from now until the 6th of November, so just over 4 weeks, almost a month, to actually provide any feedback on the decision itself. And that will then lead, as my colleague will describe, to a final decision being made potentially before Christmas. But the purpose, therefore, today is actually to describe and to explain what the proposed interim decision would do if it were implemented. So you'll hear me a number of times caveating things by saying if it were implemented, because the decision is not mine. And I would also add, and again, this will be explained a bit more, it's also not a decision of the Parliament or of ministers. So there are a couple of decisions that our founding fathers, some decades ago, determined were not going to be of a political nature, but were to be based on medical and scientific grounds. And in broad terms, there's two types of decisions. There's a decision whether or not a new medicine or a new medical device or blood or cell product goes on the market. That's made by scientists and doctors. And similarly, if for safety or other reasons one of those products has to be taken off the market, that decision's made by scientists and doctors. It cannot be influenced by ministers, by politicians, by the Parliament. Similarly, the decisions about scheduling, and this is the principle by which access to products are determined, whether something's available on prescription, in a pharmacy, in a supermarket or so on, those decisions also are made by a medical doctor or one of a couple of medical doctors known as the delegate. Again, the stuff we're talking about today are not subject to being influenced or dictated by our elected politicians, whether they're ministers or the Parliament as a whole. So I should just clarify that ministers have also been proposing and talking about an import regulation that would require an import permit for nicotine. Now, we don't know the current status of that proposal. I do want to emphasise it's a separate proposal, and therefore, because we don't know the current status of that, we're only focusing on the proposal that is within the realms of the Therapeutic Goods Administration and is to be made by a senior medical doctor. So we'll be just explaining what the triggers were, because this has been a fairly long process. The current status of nicotine, what are the proposed changes, and what that means for consumers, doctors and pharmacists. And then my colleague, Avi Rivera, will talk a bit about the scheduling process and what the decision maker has to take into account. This is all laid out in detail in law and regulations. And so the factors aren't just dreamt up arbitrarily. They're actually written down in black and white law. Then we'll have question and answer period. Now, we already have had 30-something questions submitted prior to today. We have had some in a previous webinar submitted, and we very much hope that, as per the previous seminar, where we had about 50 or 60 questions submitted during the seminar, that people can submit questions, and we'll tackle them at the end of the session. Now, often you'll get 2 or 3 questions that are very similar, and we'll attempt to cover the general theme rather than necessarily the words verbatim. We will also, depending on the sheer number of questions we get, do Q&As, further Q&As on our website that respond to the questions that we've received. So just to emphasise, scheduling, which is under TGA, is separate from this proposed prohibition on importation of nicotine unless if there's an import permit. The import permit business is actually government regulation, and that is in the political domain. And whether and when and how that may or may not be implemented is really up to ministers. Today I'll be talking about the scheduling. So what's the current status in law about nicotine fluids and nicotine e-cigarettes? Well, in a way, the status is already quite clear. So if nicotine is used for smoking cessation, it's already a prescription medicine. So some of the media that said we're making it a prescription medicine for smoking cessation is actually quite inaccurate. However, there is a lack of clarity about the Commonwealth status in law of nicotine for non-medical uses. So already in every single state and territory, sale of nicotine for e-cigarettes or the liquids is actually illegal. So if a vape shop or a convenience store or some other source is actually selling nicotine, liquid nicotine, that's illegal under state and territory law in every single part of Australia. And possession, even if you're buying it from overseas, is illegal everywhere except in South Australia. And that derives from the fact that in law it's a dangerous poison. So there's a bit of confusion then about the status of nicotine e-cigarettes when they're not for therapeutic use. The confusion relates to Commonwealth powers because it's quite clear that under existing state and territory powers, sale is illegal everywhere and possession is illegal everywhere except for South Australia. So what is the issue other than clearly there are differences between state and Commonwealth powers and so forth? Well, there's essentially two broad policy goals for e-cigarette use from an overwhelming majority, not all, but the overwhelming majority of healthcare professionals and public health physicians and so forth. The first, and I guess primary concern that many healthcare professionals have at the moment is the increase in the use of e-cigarettes by youth. And if we look at those statistics that are up there, and they're publicly available numbers, in Australia, the numbers are lower than elsewhere because of the restricted access to e-cigarettes, but nonetheless, between 2016 and 2019, there was a doubling of e-cigarette use by Australians under 24, 15 to 24. Among high school kids in the US, almost 30% are currently now e-cigarette users, and that's more than a doubling. And in Canada, in 2 or 3 years, it's gone up by, in 2 years, I should say, it's gone up by almost 2.5 times, or 2.5 times the use. And there's two broad concerns. The evidence is getting stronger and stronger. And a recent study commissioned by the Australian National University, which looked at all the reports on e-cigarettes and youth, actually gave overwhelming evidence that there is a tendency for e-cigarette users who are young to move towards smoking. And the public health concern is that of undoing years and years of success. Indeed, Australia led a lot of the world in actually smoking reduction, especially among young people. And there's a very serious concern among health professionals and public health professionals that the advances there could be undone. Even for youths who may, because of a smell or taste, never be interested in smoking a combustible cigarette, nicotine is not a very healthy substance. It's actually quite poisonous. In fact, it's used as a poison in gardening, as an insecticide, because it kills living beings. And there are serious concerns that exposure to significant levels of nicotine, especially the younger you are, can influence the development of your brain and also influence the general health of the individuals. So the first policy objective is to reduce access and therefore reduce the so-called on-ramp for youth taking up use of nicotine. The second policy objective is to maintain simple and straightforward and legal access to nicotine for adults who are wanting to try e-cigarettes to assist with smoking cessation. And here are a number of the various reports on nicotine and impacts on the brain and impacts on smoking cessation and use of e-cigarettes and so forth. So just to repeat, this is an interim decision and we do seek submissions on it for the period to 6th of November. So if it were made final, it would mean that nicotine e-cigarettes and liquids containing nicotine would only be able to be supplied in accordance with a doctor's prescription. And as I said, it clarifies the scheduling because currently for human use, human therapeutic use, they are already prescription only. And currently the sale and possession, except for South Australia in the case of possession, of non-prescription nicotine e-cigarettes, they're actually already illegal. And the idea of linking it to doctor's advice is to get appropriate lifestyle advice from your general practitioner. And because involvement of general practitioners in smoking cessation, involvement of a second person who is committed to and interested in your general personal health, certainly is shown to significantly increase the ability of people to give up smoking. And so it's really striking a balance between protecting young people from the risks and encouraging access to e-cigarettes to assist smokers to quit. Now, another concern with e-cigarettes has been that of accidental ingestion, and there was sadly a toddler died a couple of years ago in Australia, and there's been a larger number, between 10 and 20 in North America, who sadly have died after consuming liquid nicotine. And there's been the deaths are the tip of an iceberg in that there's been a significant number of increases in calls to poison centre, especially after young children who can be attracted by the fruit and candy flavours and so forth. And you can see just in Victoria in 1 year, the numbers went up by 50%, the number of calls to the Melbourne Poison Centre. So one option that the delegate wants public feedback on is the use of child-resistant packaging for e-liquids. I should note that a number of the current e-liquids already have child-resistant screw caps and so forth on them. And so there are a number that are already provided in child-resistant packaging. Now, if this interim decision is made final, and again, I'm emphasising that it is an interim decision, and by law, we have to consider all submissions made, or the delegate does, in the period to 6 November. It would still be legal to import e-cigarettes nicotine-containing e-cigarettes under the TGA personal importation scheme, but you need a valid prescription from an Australian doctor and 3 months supply at one time. And they're for your use or an immediate family member who's named on a prescription. So what happens if either individuals or companies attempt to import? Well, a company can import with a prescription medicines wholesale approval. So the company obviously doesn't need a prescription in the name of the company. There's no such thing. So the same way companies importing medicines now, they require a state or territory prescription medicines wholesale approval. And that's a well-established process with information available from each state and territory health department. Or an individual will require a prescription to do that. So what happens? Well, because if the decision is made final, these products will be prescription medicines, they can be impounded by the border force, by customs. And customs clearly work on intelligence, they work on identifying parcels, they would certainly work on identifying if it was a commercial level shipment that didn't come in with the correct paperwork, same with any other medicines shipment that didn't come in with the correct paperwork. If the products were suspected to contain nicotine but were labelled as not containing nicotine, they can impound the products and again work closely with our department and our department's laboratories on the testing of those products. And if they don't contain nicotine, they can be freely traded. If they do, and there's not the prescription or the commercial wholesale approvals, then they can be impounded, destroyed, and regulatory action can be taken against the company. So what does this mean for consumers? Well, a consumer would have a consultation with the doctor and get a script. And essentially, it shows too that there's really 3 broad ways in which consumers could access to get that script filled. The first is for any other script. And we've been talking with the pharmacy wholesalers, the Pharmacy Guild and the Pharmaceutical Society, and this would be pharmacists who would stock nicotine for smoking cessation, e-cig vaping liquids in the same way that other products for smoking cessation are also able to be obtained from pharmacies. These would require a prescription. The second approach, which is increasing in importance, especially driven by COVID-19, but increasing as society changes, is actually using an online pharmacy. And there's a number of quite reputable online pharmacies where a prescription can be dispensed either by sending in the script or through changes brought in through COVID, through imaging and other electronic means of transferring the script automatically rather than having to find a postage stamp and lick an envelope and send it in. The third approach is, if an individual so wished, is to personally import the nicotine from overseas, but they would have to show that they have a prescription. Again, we believe that because personally importing from overseas involves paying of often high shipping fees, we've heard that sometimes the courier fees are as much as the actual cost of the liquid nicotine product itself, that there'll be economies of scale as more of these sources of nicotine for smoking cessation can be obtained locally. So what would doctors do? Well, a doctor can become an authorised prescriber for nicotine for smoking cessation, and it is only open to medical doctors registered in Australia if they fill in a simple online form that where they have to just put their name, address and APRA registration number. And it's free of charge, valid for 5 years. And once they are an authorised prescriber, they can prescribe for an unlimited number of patients over that period of time and write a script for e-cigarette nicotine. There's further information on the TGA website, because one thing that's not envisaged are particular controls on the strength of nicotine or even the types of products, salts, liquids, delivery mechanisms and so forth. And so the script would just need to say nicotine, but there is information for doctors and pharmacists derived from overseas sources such as New Zealand, which talks, for example, about if someone is a under 10 cigarette a day smoker, perhaps starting with a fairly dilute, low concentration would be suitable for them. If someone's a 2-pack a day smoker, they'll probably need one of the higher concentrations, 24, 36 milligrams per mil, or they might need to use a nicotine salt preparation to give them the same nicotine hit as high levels of smoking. And the overseas experience is that people sort of self-titrate. And so it's unlikely, for example, that a doctor would write the number of puffs on a prescription, because people will know how much works for them. So pharmacists, and as I said, there's different types of ways that pharmacists could obtain the product. One is through a local pharmacist, and because and again, it won't be up to us, it'll be the delegate, who is someone who is separate to this discussion. Because the delegate may bring this in from 1st of April or even 1st of June next year, we therefore have several months in order to finalise these arrangements. And so it may be a physical pharmacy in your local suburb, or it may be, as I've said before, an online pharmacy, or alternatively, people could personally access it from overseas. Although people are doing that now, it's a bit more hassle than if you can just get something down the road. We've been asked, what does this mean for vape shops? Will vape shops be thrown out of business? And the answer, unequivocally, is if vape shops are obeying the law now, there'll be no change at all to the business that they've been able to conduct. So what do I mean by that? Nicotine sales are already illegal everywhere in Australia. So if a vape shop is selling nicotine in Australia at a retail level, they're breaking the law. They're breaking state and territory law. Police can act. But there's two things that vape shops do actively, openly and legally. And first is to sell vaping devices. And while there's some constraints in Western Australia for those that mimic a cigarette, vape shops will continue to be able to sell vaping devices as before. And secondly, vape shops can continue to sell non-nicotine containing e-liquids. So their status and what they can do if this change comes in is no change to what a vape shop in Australia can do. And it's important to emphasise that. The second thing that we've been asked is, well, hold on, I particularly like a particular concentration or particular product or whatever. There's not proposed, in the interim decision at least, there's not proposed to be controls on products and flavours. Now, it may be that some submissions to the interim decision say, hey, we should get rid of these candy type flavours that attract kids. That will be up to submissions. But there's no controls proposed on product choices and flavours. And I imagine that in order to satisfy demand, there'll be a wide range of product choices and flavours available to those who are importing them and those who want them. One of the things that the interim decision wants further feedback on is whether there should be a requirement for child-resistant containers. And I mentioned earlier, first of all, that there's sadly been a number of poisonings, and luckily a lot of them have been close calls rather than fatalities. But a quick survey shows that already a number of nicotine e-liquids are provided in child-resistant containers. Some are, some aren't. I've talked about costs, and while pharmacies, whether they're online or whether they're physical pharmacies in your suburb, while they're individual businesses and they'll be able to set their own prices, the trade-off is, of course, that individuals who purchase from a source within Australia won't have to pay significant international courier charges, which especially during COVID are only going up and up because there's fewer flights internationally and therefore broadly domestic freight costs or international freight costs have increased. Now, what about controls from the black market? We don't have local manufacture of the concentrated nicotine liquid, so that's coming all in through imports. If the interim decision is confirmed, what it actually means is because these are prescription medicines, customs, or border force as they're called, have power to stop prescription medicines that come in either without the wholesale commercial permit or without an individual prescription at the border. Now, realistically, neither customs for things like this or quarantine for pest diseases, plants and smelly sausages and things, they don't stop 100% of things, but they have increasingly sophisticated intelligence-based tracking. So they'll focus on repeat importers, they'll focus on commercial imports, and they'll focus on tip-offs and intel. And again, we have found that for other prescription medicines, that it's been an extremely valuable way of intercepting imports of products that could otherwise make people very sick. So they will have unequivocal powers to either stop known or suspected nicotine-containing products at the border. And of course, domestic sale of nicotine is already illegal in every state and territory of Australia. And so the police have the powers to act already. I'll now turn to my colleague, Avi Ribera, to talk a bit about the scheduling process.
Thanks, John. Good afternoon, everybody. So I'm just going to run through fairly quickly at a high level what the scheduling process is and also the types of things that the delegate or the decision maker needs to take into consideration prior to making a final decision. So what is scheduling? So scheduling is a national system that controls how medicines and chemicals, and collectively we call them poisons, are made available to the public. These poisons or medicines and chemicals are actually classified into schedules, and these schedules are based on the level of regulatory control that we need to put on these substances in order to basically protect the public health and safety of all individuals here in Australia. It's important to remember that with the scheduling process that the delegate looks at these and makes decisions based on public health and public safety. So the schedules are actually published in what is known as the Poison Standard, which is a legislative instrument, and this legislative instrument is given legal effect through each of the states and territories' own legislation. So generally, each of the jurisdictions will adopt by reference the poison standard. However, they do have the ability and have on some occasions very small numbers of substances that they have decided either require additional controls or slightly different scheduling parameters. As a general rule, however, with scheduling and the poison standard, the higher the schedule, then the greater the controls that are placed on that substance. In terms of medicines, you will generally find medicines in Schedule 4 and 8 if a prescription is required, with higher controls required on Schedule 8 prescriptions, or you'll find them in Schedule 2 and 3 of the poison standard. Schedule 2 and 3 medicines, generally ones that are found in pharmacies, with Schedule 2 medicines available on the shelf for you to purchase. Schedule 3 are generally behind the counter, and you will need to talk to a pharmacist in order to be able to purchase those. Now, it can be that some medicines are actually considered unscheduled, and therefore they can be purchased in other retail outlets. Complementary medicines are often unscheduled, and therefore you can purchase them in supermarkets or in health stores. So there are actually 10 schedules within the current poison standard. We don't use Schedule 1, but as you can see there, for example, Schedule 10 contains substances that are significantly harmful, and therefore they warrant prohibition of sale, supply or use here in Australia. One of the other things to understand with scheduling is that a substance can actually be found in more than one schedule. So an example of this would be paracetamol, where in very low doses and in small pack sizes, it would actually be unscheduled, and therefore it can be sold in supermarkets, for example. But in larger pack sizes and in higher doses, and again, depending on the indication that it's treating, it could be in Schedule 2, Schedule 3, or even Schedule 4, and require a prescription. So that is something to be aware of with scheduling, that it could actually be unscheduled in some instances, but sit in other schedules, depending on its dosage. So how are the scheduling decisions made? So the process, as John mentioned earlier, is actually prescribed in legislation, and it's within the Therapeutic Goods Act that the process is prescribed, and that's supported by clauses in the Therapeutic Goods Regulation. There is also a document known as the Scheduling Policy Framework, and that goes into a little bit more detail around how the process of a decision is made and the types of information, submissions and advice that a delegate needs to receive prior to making a decision. As John mentioned earlier as well, the decisions are actually made by a senior medical officer within the Department of Health, and it is independent of any minister or any member or elected politician. Specifically within the Act, Section 52E actually prescribes the criteria by which the delegate must make a decision. And consideration from the delegate needs to be taken on the risks and benefits of that medicine, the purpose for which that medicine is to be used, the toxicity of the substances, and as well as the dosage, the formulation, labelling, such as any warnings, the packaging and presentation of the substance. Now, the delegate can take into consideration other matters, but those matters must be necessary to protect public health. So it is an important point. John mentioned it, and I said it earlier as well, that the decisions have to be in light of public health and safety. The other thing that the delegate needs to do prior to making a decision is that they must seek advice from an independent advisory committee. And for scheduling, we have two committees, the Advisory Committee on Medicine Scheduling and the Advisory Committee on Chemical Scheduling. So the delegate will seek advice from one or both of those committees, but they can also seek advice from other independent statutory advisory committees that we have here at the TGA. So in terms of the process that we've gone through so far, the delegate actually made the initial announcement with regards to considering the scheduling of nicotine on the 17th of April. At that point in time, and as is required under the legislation, the delegate then sought initial feedback and consultation from the public on that initial announcement. Now, that opened on the 17th and the first period of consultation closed on the 18th of May. Following that, the delegate then went to, in this instance, a joint meeting of the advisory committees to seek advice from them on the scheduling proposal. At that point in time too, all the members of the committees actually received a copy of all the public submissions as well to help inform them prior to making advice to the delegate. Following that meeting and the advice from the advisory committees, the delegate then made the announcement on the 23rd of September with regards to an interim decision on scheduling and the S4 entries for nicotine. In making that decision, the delegate did take into consideration the advice from both committees and also the public consultation submissions up until that point. At the same time, the delegate then issued a second request for public consultation on the interim decision, and as John mentioned earlier, the submissions close on the 6th of November. Later on in our presentation, we'll actually have a link within the presentation that will actually take you to the page for those of you who would like to provide a public submission to us so that you can use the form that's available there. One of the things that I'd like you to consider when you are making a public submission is the 52E criteria by which the delegate makes the decision. So when you provide your submissions, if you can link it back to those criteria, then that can help the delegate in making a decision and take consideration of your actual submission. As John also said, we anticipate that the final decision will come out in mid-December. It is up to the delegate to actually decide when that announcement will be made, as we anticipate that will be the date, unless, of course, the delegate does decide to seek further information on that. So in terms of the next steps, as John mentioned, we are running these public information sessions and these webinars to provide you with information around what the current situation is and what's happening from a scheduling process. We will be publishing these slides on the TGA website, and as I said earlier, the slides will have that link to allow you to go and make your own submissions as well. Following this process, the delegate will review all the public submissions and, as I said, expected to make a final decision mid-December, and as John mentioned, potentially with an implementation date of 1 April or June to allow industry and individuals time to work out what needs to be done in order to get access to these medicines should the final decision be in line with the interim decision. So, as with anything, we have a lot of information available on multiple websites and social media, and we've got a few of these links available to you as well, and certainly once the presentation's available on our website, please do not hesitate to check those. Following this, and we are going to move to a Q&A session next, if there are any specific questions or technical issues that you would like to discuss with us, please email the Medicines Scheduling Secretariat at medicines.scheduling@health.gov.au with your questions. I ask that in the title, if you could please just put in the subject line follow-up from the nicotine webinars questions, then we'll be able to look at that. We will be posting a series of Q&As on our website, and while it won't address every single question, what we will be doing is grouping those questions and addressing them in single Q&A responses. We'll also do that with any questions that do come through to this email address, as we're probably not going to be able to answer each individual question via a single response. So look, that's a high-level overview of the scheduling process. So I will end it there in order to allow us enough time to go to Q&As, and I'll hand